Hey everyone, Megan here from Women in Crime, and thanks for joining us tonight to talk. There we go. Thanks for joining us tonight to talk about the Diddy trial and Coberger. We're going to focus a lot on what happened today in court. A lot of people had questions, so it's just me tonight, just Megan. Amy is unable to join in terms of Women in Crime, but we have a special guest here to help us break down a lot of what happened behind the scenes. And this is Mitchell Epner. He is a former federal prosecutor, assistant U.S. attorney, who is now practicing defense. He's a defense litigator, both criminal and civil, practicing with Cudman, Tracton, Allo, and Posner in New York. Mitch, thanks so much for being with us tonight.
Thank you for having me. Pleasure to be here.
Oh, yes. It's a pleasure to have you. So this was a huge week. First of all, it's a huge week in true crime. Before we even get there, you are a former federal prosecutor. Can you tell us where you practiced?
Sure. So from 2001 to 2004, I was a federal prosecutor in the District of New Jersey. And for the last year that I was there, I led the anti-trafficking group in the District of New Jersey. And back then, it was definitely not seen as something that would lead to moments in the public spotlight. Very few people understood what sex trafficking was. We were doing sort of cutting edge work. And I had no idea that 20 some odd years later, this would be something that everybody had an opinion on.
Right. Oh my goodness. So even when I teach about human trafficking in my Women in Crime class in particular. And I have to say, it's kind of a newer area in terms of how we understand it, how we prosecute it. And I think it's pretty misunderstood by a lot of people still. So I don't think the general public has the same idea about it as maybe an insider like yourself does. And so I think that came up a lot at this trial. This is a trial, or the Diddy trial, when we talk about that, was about trafficking, racketeering, prostitution. There were a lot of things going on in this case. And from the beginning, I feel like there were a lot of questions about whether or not the prosecution could make this work. Was this trafficking? Would people see it? How do we understand racketeering? So you can kind of take us through both sides of that. It's pretty big.
Back when I was a federal prosecutor, actually one of my colleagues was Mark Agnifilo, who was the lead counsel for Sean Combs here. And back then he was the head of the organized crime strike force. So he and I used to have long conversations about what does and doesn't fit inside of RICO and what is and isn't sex trafficking. And those were precisely the questions that were at play here. Now, traditionally, and it's weird to talk about traditionally when you're talking about a new field like sex trafficking.
Right.
But traditionally, people thought of sex trafficking as the type of cases that I was helping to make 20 years ago, where a trafficking organization would take poor women, often from places like Mexico, bring them into the country under false pretenses, telling them that they were going to work as chambermaids at hotels and other jobs that undocumented aliens do. And often they would be underage. So they were girls, and girls cannot consent.
Right.
Very important thing for everybody to remember in thinking about this case and other trafficking cases. And in those sorts of cases, the trafficking was pretty egregious and very easy to understand. These were women who were brought here, often raped serially, until they finally agreed to stop fighting against acting as prostitutes. And the traffickers would collect money from the customers to have sex with these women who were the victims. And the women often had their identification papers taken away. In Mexico, it was largely their voting ID card.
Mm-hmm.
And they were told that if they tried to escape, number one, they would be hunted down. Number two, without papers, they would be treated horribly by US law enforcement. And number three, their families would be hunted down back in Mexico.
Right.
That
overt threats, acts of violence.
And keeping people as hostages for months or years on end. And that was not what was presented in this case. With Cassandra Ventura, with Jane, these women were being put up in fancy hotels, mm-hmm. traveling the world, mm-hmm. going to, for example, the Cannes Film Festival. And the trafficking was not to make money for, as alleged, was not to make money for Sean Combs, but rather it was Sean Combs paying money to have male sex workers have sex with his girlfriends in front of him for his sexual gratification. And there was also no question that at the beginning, both Cassandra Ventura and Jane were volunteers. And the case was about whether at some point they were no longer volunteers, but rather they were victims who were only continuing to participate because of coercion, and the coercion taking the form of physical violence, threats of violence, and blackmail about releasing these videos of these freak-offs. So that, fitting that into the jury's understanding of what sex trafficking is proved to be too much for the prosecution here.
Okay. So that was a lot. Thank you for that explanation. That helps, and it makes sense. It proved to be too much for the prosecution. So I've been watching as much as I possibly could. And I've been asked my opinion on this by a couple of different people. And what I always anticipated was that the jury wasn't going to make the leap to everything. There was going to be convictions, but it wasn't going to be straight across the board. That being said, let's talk. Diddy was only convicted on 2 counts here. And those are transportation for prostitution counts, which hold, as I understand it, a maximum of 10 years.
You've got that precisely right.
But the maximum, also want to talk about the fact that the maximum doesn't really tell you what he's going to be sentenced to. And even I know this as a former federal officer. When we used to work on cases, or when I would get a case, we would go to the sentencing guidelines. What's his criminal history? What's the offense? Let's start tallying the score.
So I'm holding them up for the people who are watching. The sentencing guidelines give you a much better idea of what he's actually facing.
So that's one of the things I think. No one really talks about the sentencing guidelines. They always talk about the stat he's facing up to. And I'm like, that's not really a realistic breakdown, though. So, I mean, instinctively today, I went and looked for my guidelines book, which is very old, by the way. I would need a newer one because it's not in date anymore. And I couldn't find it. I realized my book is actually at school. But do you have your guidelines out? Do you have any calculations yet? Or is it too premature to even ask you?
So we know what each side's preliminary guidelines calculations are, because as part of the bail hearing this afternoon, both sides put it in writing to the court.
All right. So what do we know? That's great. I didn't know that.
So the defense went first, and the defense's argument was that the guidelines here are a level 16, which leads to, with criminal history category of 1, which leads to a sentencing range of 21 to 27 months. Sean Combs has already served 10 months in prison. Yeah. The defense is going to argue that he should get extra credit because The conditions at MDC are so awful, and many judges in the Southern District of New York have said ordinarily I would sentence this defendant to, let's say, 3 years, but because they spent a year pretrial at MDC, I'm only going to sentence to 2 years because the conditions there are so awful. So that was the defense's argument.
Before you go to the prosecution, just a quick interruption. I hate to interrupt, but I will say I worked in the MDC a lot. So that was where most of my interviews took place. It is a bad place. It really is. When we talk about jails, it is notoriously horrific. I hated going in there, and so while I don't sympathize at all, I certainly understand the argument that judges are more sympathetic to people who are spending time there because it's bad.
So I'm going to agree with you. I have been in and out of MDC far too many times in my career, and it is a horrific place. In times when I have had in civil rights cases, I've had witnesses who've been transferred from state prisons like Attica and Auburn brought down to testify in New York, and they literally are champing at the bit to get out of MDC and go back to Attica because they think Attica is a better place to serve time. And I have my own Substack. About a couple of years ago, I wrote a lengthy piece when Ghislaine Maxwell was awaiting her verdict at MDC about how awful MDC is. And it is truly an indictment of the system that even after federal judges have repeatedly said to the Bureau of Prisons, this needs to be improved.
Right.
Even for a prison, this is horrific, that nothing appears to have changed over the past 5 years.
This is really shocking if you think about it, because it's been ordered, right? Like to be changed. And I am surprised. I don't want to get too off topic here because I covered Ghislaine and I'm like, oh, now I could talk about her, but I'm going to bring it back because you gave us the prosecution. So you gave us the defense. So the defense said the guideline range should be 21 to 27 months. So as we know, 21 months is less than 2 years. In the federal system, if you're good, you only serve 85% of that sentence regardless. So if we take that down, let's say we take 21 months down to 85%. I'm really bad at math. So was that like 16 months?
Call it 16 months.
16, thank you. He's already done 10 months and he's done 10 months at the MDC. So we could possibly, if the defense suggestion is taken, we could be talking about either no time to just months.
Right. And even if you were sentenced to, say, 21 months, which becomes 16, under Bureau of Prisons protocols, in the last 6 months of a defendant's sentence, the Bureau of Prisons has the discretion to put them into a halfway house.
Right.
So in the defense world, Sean Combs looking at potentially no or minimal additional jail time.
And I don't think people understand that. That's why I wanted to have you just clarify that. I know we'll go to the prosecution side because everyone's hearing this 10 years. Oh, he's going to get 10 years. No. Okay. So, by the way, sorry, people, I see a couple people in the comments. Hi to Andrea, Tricia, and a couple people who are joining us. Thank you. If you do have questions, feel free to drop them in that chat because I am scanning it. And even with my bad eyes, I can see some of them. But okay, so Mitch, will you take us over now to the prosecution, what they're asking for in terms of those sentencing guidelines?
So the prosecution's argument is that the actual guidelines add up to a level 24, which get you to looking right now.
24, we're still in criminal history category 1. You can't change that.
Everybody agrees criminal history category 1.
Right.
So that would get you to 51 to 63 months. And the way they get to that much higher number is they say, first of all, for the for the interstate transportation, which is also called the Mann Act, and that's what I will say just because it's easier to say. For the Mann Act, under the sentencing guidelines, each individual sex worker who is transported across state lines is treated as a separate count. And therefore, under the guidelines, because these...
the sirens on your end?
Yes. I'm in Midtown Manhattan, and somebody has done something wrong near St. Patrick's Cathedral.
All right, that's what I thought. I just wanted to clarify. Okay, go ahead. Keep going, please.
To get a little bit sentencing guidelines wonky for a moment, because Mann Act violations are counted as separate groups, once you have 5 or more separate counts, even though he was only convicted on 2 counts, you add 5 levels. So you get up to a level 19. Okay. The defense was saying it's 2 counts, therefore you go from 14 to 16. The prosecution says, no, it's 14 to 19. And then they want to add on top of that 2 additional points for being an organizer or leader of the enterprise.
Yes.
And 3 additional points for obstruction of justice for example, trying to bribe the staff at the Intercontinental Hotel to get the videotape back. Now, these are all going to be highly contested things, but if you take the prosecution's view, then on a sentence of 51 to 63 months, he would actually serve an additional few years in prison, even giving him credit down the 85% and so forth.
So let's give him credit. So let's say 50. I'm just assuming also that he behaves in prison. That's just an assumption. I always go with that. 51 months. Let's assume that's 85%. If it's 85, does that bring us down to about 42 months?
It does. And remember, there's also the First Step Act. So you can turn that 50% deduction into 15% deduction into a 50% deduction. Because this is his first offense.
So then we're talking about 50% off of 42 months.
Right. So we're still talking about
22 months.
Yes, but it still would be, even a day in prison is very difficult. That is one of the first things that I learned as a prosecutor.
That's a good call.
And one of my first bosses literally had baby prosecutors go spend a couple of hours in a holding cell so that they would understand what it was they were asking the judge to impose on people.
Yes.
So all of this is to say that none of what Sean Combs is looking at sounds like 20 years, which if you read some of the news stories, they just take 10-year maximum times 2 points and say he's looking at up to 20 years. I don't think that's a realistic view of what's likely. And for people in the chat and so forth who say this is disgusting, I'm not saying that this is the way things should be. I'm telling you, based upon 30 years of experience, this is how things are.
Well, let me say, a couple people in the chat are saying disgusting and gross, but I will say I was happy to see, and look, we can talk about our personal opinions, but other people and our audience is great because they like to engage and learn about this. And I don't think that I've shared enough about sentencing guidelines. People are also saying that they didn't know about the guidelines and who thought, how much or who thought federal sentencing guidelines would be so interesting. LOL, which I actually love to hear because I had to geek out to federal sentencing guidelines for a long time. However, let me also say that the federal sentencing guidelines, when I worked in federal probation, they were mandatory. So there was no departing from the guidelines. The judge had to sentence within. Of course, the year I left federal probation, they became advisory. So the judges have to consult with them. I know since such time, some judges still will stay pretty strictly with the guidelines. Some will depart from the guidelines. I don't know very much about the judge in Diddy's case. Any idea?
So he's a new judge.
Right.
And he does not have a prior criminal history. He was not a criminal practitioner before he took the bench. So we have very little to go on what his sentencing practices will be. Generally, in the Southern District of New York, for a individual who has no criminal history, the sentences tend to be at the bottom of the sentencing range or below it.
Yes.
So there are other districts, predominantly in the South, where judges regularly sentence at the top of the sentencing range. And the sentencing range can be quite broad, especially at the higher levels. It can be many years from the bottom to the top. When you're at the lower levels, a span of 6 months is more regular.
Yeah. Okay. Thank you for that. That's like inside baseball that, not everyone knows. I also want to say for my audience, if you are interested, I do an activity in my class where I actually give a case scenario. I give my students the guidelines. We run through it, and then you know how it works. So if anyone wants to see how it works, we could do that on my.
I'm seeing a really good question, and I'd like to address it if that's okay.
Of course.
So the question was, why was this not sex trafficking, even though it was interstate transportation for purposes of prostitution? And that entirely turned on the question of coercion. If an individual is coerced into a commercial sex act, that is trafficking. If a person is not coerced, it is not trafficking.
Right.
And here, the defense, during their cross-examination, because they put on very little evidence of their own and no witnesses of their own,
right,
were able to point out things that led the jurors to, at a minimum, still have a reasonable doubt about whether or not there was coercion. And I'm going to start with Jane, who was the second witness, because I think it's more stark what the defense was able to do there.
Yeah.
First of all, they were able to show text messages where Jane said, "I'm not into it tonight," and it didn't happen. They were able to show that Sean Combs was paying, and still paying, $10,000 a month for her apartment, and was still paying for her lawyer. And at various times during her testimony, Jane either sounded like she was forced to do things against her will, or sometimes she said, well, at that time I was happy to go along with it.
Right.
And it wasn't like there was a particular break in time where Jane said, well, up until this date, I was down with it, and then after that, I was forced to. With Cassandra Ventura, it was more subtle what the defense was able to do on cross-examination. And I do believe, and this is something we will never know, you never know how a counterfactual would have happened if the facts actually happened that way. I wonder whether the government would have gotten a conviction on the sex trafficking of Cassandra Ventura, which appeared to me to be the stronger case, if they had never brought the sex trafficking charges with regard to Jane, which appeared to me to be the weaker case.
Okay, I'm glad that you said that, because I was talking with someone else about this recently, and I had the same thought. I don't know. I just didn't think that for me, the case with Jane was not the strongest. But I really thought the case with Cassie, I thought the prosecution made it. I thought they built it. I thought they showed it, and I got it. And I was going to ask, why didn't the jurors? Are they? I mean, we can't say are they right or wrong, but Mitch, you're saying maybe something is, if maybe the two, if we just stuck with Cassie, then perhaps they would have seen it a little bit differently.
So in my training and experience as a trial lawyer, we're taught to have a strong mount and a strong dismount. Start strong and strong. The government started very strong. I thought that the first week of their case went in really well. They were able to get in the video from the Intercontinental Hotel, which was horrific, right up front. They were able to get Cassie on the stand. and she was 8.5 months pregnant, which I think tends to make people think of sex in terms of childbirth rather than sex in terms of sport, or whatever you want to call what those freak-offs were.
Yeah.
But the trial went on for another 6 weeks after Cassie left the stand.
Right.
And the dismount, the ending, is important. And we call it recency bias. The thing that the jurors heard last was testimony from Jane, which really was, to my mind, equivocal on the question of coercion. And then there was also ending testimony, which was incredibly dry, because in order to make the RICO claim, they had to prove that Sean Combs's entourage was a criminal enterprise, was itself a criminal conspiracy. So you got a lot of very dry testimony about who was renting the hotel rooms, who was buying the baby oil and the Astroglide and the other things. And I think that weak ending hurt the government's case.
Yeah. Yeah, no, that certainly makes sense. The video that they were able to enter in the beginning, and everyone has seen that video, of Cassie, of Diddy beating Cassie in this public place, and it's brutal, it's vicious. And I thought it was established that this was in response to Cassie not wanting to participate in this freak off. And like, for me, that really showed the violence, more than coercion, more than fraud. And I thought they would bring, at least with that powerful testimony connecting with the video, I thought that for sure would kind of cinch the case with Cassie. So maybe what you're saying helps to understand it was too far in between. There was too many other things. It was just not the strongest. But I was surprised. Were you surprised that that the jury acquitted on the Cassie trafficking charge, or did you think, that kind of tracks with your own prediction?
So I've worked very hard to live by the mantra that the only thing that I know for certain about the future is it hasn't happened yet.
Yep.
So I didn't have a prediction about how the case would come out.
Okay.
But I was confident that if they convicted on Jane, they certainly would convict on Cassie, because the case with regard to Sean Combs, with regard to Jane, was weaker than the case with regard to Cassie. There was also another very strange thing that, if you don't mind, I want to point out, which is the jury tried on Monday, to return a partial verdict.
Right.
On Tuesday, to return a partial verdict, saying that they had come to a conclusion with regards to counts 2 through 5, the sex trafficking and the Mann Act counts, but they hadn't come to a conclusion with regard to the RICO. And I thought that meant that they were likely to convict on at least one of the sex trafficking, because I found it hard to imagine that they would convict on RICO without convicting on sex trafficking.
Yes.
And I'm going to geek out for just one more moment here.
Geek out.
For a RICO conviction, they need to prove an agreement to commit certain specified crimes and an organization with more than 2 members that persists over an extended period of time. And if there were other choices on the list, in addition to sex trafficking, such as drug distribution, the Mann Act, arson, kidnapping. But I really found it hard to imagine that they would convict on RICO on the basis of 2 of the other things without the sex trafficking. But as of late yesterday, at least some of the jurors were saying we're deadlocked with some saying yes on RICO
Yeah.
and some saying no on RICO.
Yeah.
But all of them had already voted no on sex trafficking
Right. Right.
because they
Okay.
had come to a verdict on that.
Yeah.
So clearly, what happened after the judge told them to continue deliberating is that the jurors who were saying it's not sex trafficking, but it is RICO, were persuaded or surrendered, and we'll never know which it is unless somebody on the jury speaks, but gave up the position that he should be convicted on RICO, but not convicted on sex trafficking.
Do you think I want to come back to the juror? I have a question about jurors. And I don't know, have you ever sought to speak with a jury after, or any of the jurors after your own cases?
So I've done that, but what I've done more often is in cases where we've run mock jury exercises,
Right.
we will have them on closed circuit cameras and we'll observe what they're saying in real time, and then we'll talk to them afterwards. So I feel like I have a pretty good frame of reference on how jurors think.
Do you think the prosecutors are going to want to talk to jurors after this? What do you think? Are they going to want to know what happened in the room?
What they want to do and what they will do may be two very different things. I think every trial lawyer always wants to talk to every juror and
Right.
find out what worked and what didn't work.
Right.
But as an office, at least until recently, the U.S. Attorney's Office usually declines to try to interview jurors about their jury service.
Yes. I don't think I would be able to resist. I understand, but yes. Let me ask you a question. Let me turn back really quick to the RICO. Do you think that the jury just, with RICO, this isn't, as I explained, and you would know much better than me, but traditionally RICO applied to our notions of traditional organized crime. Crime, mob families. Do you think the jury just couldn't see it? Like, do you think that maybe the spirit of RICO just wasn't here? Like, yes, he had people who worked for him, and they obviously did partake in some of these events, but in essence, they're not really a crime organization. Do you think that was kind of the mindset, or they just didn't see that the prosecution met the burden? And I know you can't know for sure, but
So
as an outsider.
the fact that there was at least a temporary deadlock on RICO leads me to believe that at least some of the people in the room got the prosecution's message and said, this is RICO. But at the end of the day, they either surrendered or they were persuaded otherwise. And the problem for the government in trying to make this RICO claim and this RICO case is that when you're talking about an organization that has a dual purpose, a legitimate purpose and an allegedly illegitimate purpose, it is very hard to show the contours of this organization that has to be the illegal part.
Okay.
Booking hotel rooms for Sean Combs ordinarily is not a crime.
Right.
Booking hotel rooms for him if you know he's going to engage in sex trafficking or drug distribution while he's there, that is a crime. I also think that one sort of red herring in the jury deliberations was the jury sent out a note asking for the definition of drug distribution and specifically asking whether it counted as drug distribution if the person who receives the drugs asked for them. And I think that was, and it's kind of a weird question because even junkies on the street who are buying heroin are asking for it. They're asking for it and handing over money, but they're asking for it. Very few people truly have drugs pushed on them. But the definition of distribution is extraordinarily broad under federal law.
Right.
If a person gives another person drugs, whether they get paid or not paid, and no matter what the amount of drugs is, that is drug distribution.
Right.
A bunch of college students sitting around a bong in a dorm room, if one person brings the marijuana and puts it in the bong and then hands the bong to everybody else, that is drug distribution, technically.
Got it. By their standards, yes.
But even with that very broad definition, which the testimony about what Sean Combs did would fit, at the end of the day, the jurors rejected the RICO. And since they convicted on the Mann Act, if they had just put the drug distribution together with the Mann Act, you would have had two predicates for RICO.
But they didn't see that. I have a question from Adriana. The defense and prosecution select the jurors, correct? That is correct. And there's a whole voir dire. So do you voir dire where they ask questions and they're able to strike jurors? Do you think that the defense just got the jury they wanted?
So this case was unusual in that the judge allowed the parties, the prosecution and the defense, to put written questions to the jurors before the in-person voir dire.
Right.
And I think the defense was able, through their questions, to screen out a lot of people that ordinarily would have been part of the jury pool because they were looking for a particular type of juror. And I want to talk for one moment about juror number 25.
Yes. Okay.
So one of the first notes that the jury sent out, and it was very quickly, it was within like an hour of the start of deliberations, was the foreman of the jury saying one juror number 25, may not be capable of following the judge's instructions.
Right.
For you to question him or talk to us. And the judge, very wisely, in my view, and both the prosecution and the defense agreed with this, declined to talk to them because the second that the judge talks to the jury, if the jurors reveal where they are on acquittal or conviction, that creates grounds for a mistrial. It's just a huge problem. So instead of talking to them, he just sent back a message asking them to follow his instructions to deliberate. But what we know about juror number 25 from the voir dire is that this is a gentleman, middle-aged. I think he's about my age. I'm 55. I remember him being roughly my age, who has a PhD in biology.
Okay.
And I think biology and neuroscience. So the question here wasn't, is this person capable of deliberating because he's not good at speaking English or can't, sometimes you have those sorts of issues.
Okay.
I think that what you had was a super educated juror who listened to the closing arguments and walked into the jury room and said, I know what I just heard, and that's not RICO, and that's not sex trafficking.
I see. Okay. I had not heard that before or heard that from someone else. So that is a very interesting point. The jurors didn't get to hear, as I understand it, about the arson and kidnapping. And I think someone is asking, I'm looking down, by the way, when I look down, it's because I have to read the questions off my iPad. It's backwards on my prompter. But so so the prosecution initially presented arson and kidnapping as part of their RICO case. Why, in the end, ultimately, did they drop these counts?
They didn't. You read misinformation from the media.
And what happened, or what are we misunderstanding?
So what we're misunderstanding is in the predicates that were alleged in the indictment included arson, attempted arson, kidnapping, and attempted kidnapping.
I see where you're going. Okay, go ahead.
And when it came time for final arguments and the jury instructions, somebody on the prosecution side realized that jury instructions on conspiracy to commit an attempted offense
Yeah.
are incredibly confusing.
Right.
So they
Right.
went with RICO predicates on arson and on kidnapping, but they dropped predicates of attempted arson and attempted kidnapping.
Okay.
So that is what happened there. And I see also the question of, well, why weren't the arson and the kidnapping charged as separate crimes? The answer there, I'm virtually certain, is the statute of limitations.
Mm-hmm.
There's a 5-year statute of limitations for most federal crimes.
Right.
RICO is like a magic eraser because RICO does the statute of limitations on RICO stays open and doesn't even begin to run until the last act that's a part of the conspiracy. The conspiracy here was alleged to have lasted for about 15 years.
Mm-hmm.
All of the bad acts that were alleged to have been a part of the RICO for the first 10 years of the conspiracy could not be charged as standalone crimes.
Yes. Okay. Thank you for explaining that for the statute of limitations. Let me ask you a question, Mitch. Did the prosecution overreach? Was that part of the problem here? Was it just too much? Should they have focused on a couple of acts and not gone for RICO, or is that just, what do they call it? Like 2020's hindsight or Monday morning quarterbacking?
I was about to make the it's Wednesday afternoon, so it's difficult to quarterback.
All right.
But even as the case was going on, I was very concerned about the RICO.
Yeah.
And I felt like the need to prove a single conspiracy that lasted for 15 years.
Yeah.
Was a difficult thing. And I felt, and we'll never know, and the prosecutors who handled this case are incredibly well credentialed.
Yeah.
But my pattern recognition tells me that they may have decided to charge the RICO because it allowed them to bring in bad acts going back 15 years. And if they had only charged the sex trafficking, they might have feared that the judge was going to say, okay, you can only bring in the events about those particular acts of sex trafficking and not this 15-year-long story. And I suspect that having decided, well, we really need to get this whole story out there, and RICO is the device that allows us to do it. They then were stuck with this very clumsy, awkward prosecution that lasted for 2 months.
That's awful too. Clumsy and awkward. At some points, I thought it was going so well, but I always thought, I was always thinking RICO was just a bridge too far, I think. And, I talk a lot about in my own research and classes about prosecutorial overreach and overcharging. And I just don't know if RICO was the right way to go, even though, obviously if they'd convicted him of RICO, people would be going, oh, that was great. It was an innovative use of RICO and whatnot. And so I really couldn't say for certain. However, at the end here, someone wanted to know also, I don't want to pass by a question, but someone was asking for our predictions now that there's no RICO, there's no trafficking. We've talked about the guidelines. Someone wanted to know, what do we predict? What do you think he's going to wind up with? And is he going to wind up on bail?
So we know the answer to the bail question already. The judge held a bail hearing this afternoon, and he rejected bail. So,
but he can't readdress that. That's it.
I mean, technically he could, but there would need to be new facts. And since the biggest new fact that I can imagine, an acquittal on the main charges, already wasn't enough,
Okay.
I'm not wishing it upon him, but if for
done.
example, Sean Combs's mother went from being just an elderly woman to a woman with severe health issues who
Okay.
and they were asking for him to be allowed out on bail so he could be at her deathbed.
Okay.
That's technically possible,
But
but,
that's it. He's at where he's at. Okay.
he's going to be there in all likelihood. Now, what will the judge sentence to? I have no idea.
Because we don't have enough information about his sentencing history.
Well, also because I think that the prosecution has indicated, at least as of today, they're going to be looking for up to 5 years. The defense, I'm positive, is going to be looking for time served. And what we don't know is how the judge is going to handle acquitted conduct. Because, and I know I'm getting very into the weeds here.
Yeah.
But the sentencing guidelines operate at a lower standard of proof than a criminal conviction does. And the Supreme Court has said, even if a defendant is acquitted by a jury on something, the judge can sentence them as if they did that thing, because the jury could say, well, that wasn't proven beyond a reasonable doubt. And the judge could say, yes, but it was proven by a preponderance of the evidence. And that question is going to absolutely be front and center here, because the government has said that they are going to seek a sentencing enhancement on the basis of coercion. The jury rejected coercion, implicitly saying that coercion was not proven beyond a reasonable doubt.
They did.
The judge could say, it wasn't proven beyond a reasonable doubt, but it was proven to me by a preponderance of the evidence. And on that basis, I am going to sentence on the basis of coercion and violence. And if he does that, then 5 years might not even be enough.
So just for lay people here, because you did get into the weeds a little bit. So the jury has to consider the standard of beyond a reasonable doubt. So when we equate that with percentages, that's, I mean, as I teach it, it's usually about 99%. You have to be really, really sure. But preponderance of the evidence, which is the standard the judge is considering, is a much, much lower standard used in civil trials and civil cases. And that's kind of like, you just have to be a little bit more sure than not, than someone is guilty.
The example that's given is, if you imagine the scales of justice, and each side has, 100 pounds on it, and you just put a feather on one side.
Yeah. That
feather, which makes the scales tip, is enough to be a preponderance of the evidence.
I also find very interesting about the guidelines, the sentencing guidelines, and I learned this as a probation officer and handling so many cases, is that, it was the guidelines were designed to make everything exact, so that there was no discretion anymore, right? Like, we're going to take all the discretion out. However, I would have a case and I would investigate it. I would come up with my criminal history. Criminal history is pretty exact, but I'd come up with my offense level and then come up with my sentencing range. And I'd go into my supervisor and she would draw a different conclusion, right? A lot of this, of what you're talking about in the sentencing guidelines, is subjective. Whether or not someone is the leader of an organization enhances their sentence, but that's subjective. I remember when we would look at robbery, it was like harm done, bodily harm. It was like serious, not so serious, in between that, critical. Like, there's all these different levels. So the guidelines don't exactly make a sentence exact. And what you're talking about illustrates that. The defense, of course, is going to be on the low end, but there is a great variation between what we're talking about here.
Yes. Now, having said all of that, I would be very surprised if it ended up over 5 years, because that's what the government is seeking. But between time served and 5 years, I really don't have a guess.
I do, but I'm not going to guess because I don't want people to say you were wrong later, but I do have a guess. So maybe I should write it down and show my audience later. Is this justice? Should people be pleased with this verdict? Should people be outraged? Should we be nothing? Is this indicative of money, and this is what money buys you? Is this a failure of the system? Like, someone asked me on another show, what's my takeaway here? And I said, every trial has a different takeaway. Celebrity trials represent the smallest fraction of cases. Trials in general represent the smallest fraction of justice because most justice is doled out via plea bargaining. But what's our takeaway, the public's takeaway from this trial and the outcome?
So I'm going to take what I think is the easiest of a lot of very difficult questions that you just asked.
Sorry.
And I'm going to say, does this speak to inequality in the system because of resources? And the answer to that is 100% yes.
Yeah.
And it's unfortunate. And I have many friends I am a criminal defense attorney. I'm also a civil attorney. I have many friends who are criminal defense attorneys who charge more than I do. I have friends who charge less than I do. And I have friends who are great criminal defense attorneys who are public defenders. Mm. But the resources that Sean Combs was able to bring to bear here are truly extraordinary.
Right.
I said on another broadcast today that I would not be surprised. I'm certain that this was a 7-figure defense, and it may have been an 8-figure defense. And
oh, wait. Whoa. Okay. 8-figure. Okay.
Yeah. The attorneys who the billing rates for the attorneys involved here almost certainly were all well over $1,000 an hour. Mm-hmm. And in preparing for trial and going to trial, you're talking about months upon months where each attorney was probably billing over 200 hours a month, maybe sometimes over 300 hours a month.
Okay.
If you put that together and you have a team of roughly 10 attorneys, and you're talking about say 2,500 hour attorney hours a month, and you're talking about a blended billing rate of 1,500 a month, and you're talking about nearly a year of doing the work, you get to eye-popping figures of over $10 million. Mm-hmm. And people have asked me, well, what do they spend all of that time on? They spend all of that time on trying to find the things that they can use during cross-examination. And there might be a single line of cross-examination might have 100, 500 attorney hours of work behind it. And there might be 8 other rejected lines of cross-examination that had an equal amount of work that was done until they decided, we can't go there. That's not what's going to be useful. We're not going to concentrate on the text message that was sent on June 12th. We're going to concentrate on the text message that was sent on June 13th.
Right.
Because if you push too hard on June 12th, you get to this bad text message. Right. And we don't want to do that.
Question. There was, I know early on, there was an offer made, a plea deal that was offered to Diddy, and he rejected it, and that was made public. I only heard a rumor about what the offer was. Do you have any idea, or can you speculate as to what kind of offer he was made?
I have no idea what sort of offer he was made.
Okay.
But I will speculate that if he was offered the verdict that he got today, he would have taken it.
I mean, I think that's the definite given. I read something in one place that he was offered 12 years. And I remember going, wow, he's up against 15 years, but the life and whatnot, will he regret taking that plea later? And I'm sure he has no regrets in terms of rejecting the plea offer, although I wish we kind of knew what it was. What do you think? What's next now? When should we expect? Or I didn't see the date. When are we looking at sentencing?
So the judge said sentencing hearing on October 2nd.
Okay.
But as soon as he said it, Mark Agnifilo, the lead defense counsel, said, "My client is going to be in MDC between now and then. We want an expedited hearing." And the judge said, if you want an expedited hearing, we will do everything we can to get an expedited hearing. Now, you have more experience than I do on preparing a pre-sentence report.
Yes.
But I think that in a case like this, the initial draft of the pre-sentence report, which can't really start until there's a interview by the probation officer of the defendant.
Yep.
That the time from the interview to the draft report could be as short as, a week, 10 days.
It could be, definitely. So obviously I'll just say his case will go to the top of the pile and his case will be assigned right away, I'm sure. Like to think not, but yes, it will. And it's kind of funny because I was thinking back, oh my gosh, I was trying to think about the cohort of people I worked with, like who might get this pre-sentence investigation. And then I realized a lot of the people I worked with probably have retired by now. So I'm not sure that I know who's going to get it, but it could be very quick. And also they're going to interview him. But I'll talk to my audience more about this. He's likely not going to say anything about his offense. He's going to talk about his family, his upbringing, his current situation. These are a lot of the characteristics that was traditional probation work before sentencing guidelines, when you got to know someone and their real background and all the factors about their family, their education that ties to the community. Those things used to be historically much more important. Now it's much more about the offense and the criminal history. I suspect, though, the pre-sentence investigation will be done pretty quickly, if I had to guess.
And one of the things that as a practitioner I can talk about is with regard to the offense conduct, both the prosecution and the defense will be pointing the probation officer to particular parts of the trial transcript to say, here's what happened and here's the evidence of what happened. Mm-hmm. And in particular, there's going to be a very contested question around this issue of coercion.
Yeah, I absolutely think so. I'm really interested to see which direction this goes in. I will say, on just a personal note, I was somewhat disappointed, though I understand. So there are cases that I have long, opined on that I've been disappointed, though I understand why the jury decided what they did. And I think this is probably one of those. I know that we've been here for almost an hour, so I will only keep you just a few.
Well, there is one other question that I want to address.
Oh, was it in the chat and I missed it because I can't see? Right.
The question is, I wonder if criminal attorneys ever say no to large amounts because they believe the person convicted is guilty and is just a bad person and deserves to be in prison. And I will tell you that is not a thought process, but there is a close thought process that sometimes has happened for me, and I know for some of my criminal defense colleagues. And I don't say this as bragging. This is within the morality of being a criminal defense attorney. I am admitting to a moral failure right now. There are some times that a defendant has done something that makes me feel like I can't give this person zealous advocacy. Right. I can't invest myself in representing them. And because I can't do what the system demands that I do, I need to decline the case. And I'll give you an example.
Okay.
I believe that Nazis deserve criminal defense. I could not defend a Nazi because they're Nazis, and because I believe that outside of the context of my being their lawyer, they would want to kill me and my child and my family and so forth. But in the ethics that are required of criminal defense attorneys, you cannot hang back and say, I'm going to give this defendant less than my best because I think they're guilty.
No, you can't. But you point out something interesting. You can, as a private defense attorney, you can turn down a client. And as a public defender, they really are much more limited in turning down a client. So I think that's something important to point out. And yes, I don't think that means you change your representation, but you do have more freedom in your capacity now to say, hey, I don't want to represent this person. correct?
Yes,
Yeah.
absolutely. And one of the problems that public defenders have is that they are they are really strapped for resources,
Totally strapped.
and
Oh, fair.
and the the people who are the federal public defenders who I served with when I was a federal prosecutor, um, were by and large really great attorneys.
Yeah.
Some of them have gone on to be, for example, federal judges,
Right.
um,
Right.
and clearly are as brilliant as anybody on the bench. Some of them have gone on to continue to be federal public defenders and are defending hopeless cases with virtually no resources.
Right. Okay. Very fair and totally true. So, we have talked a lot about Diddy, and I just want to close out a couple moments here because I know people want to hear about Brian Kohberger as well. And I will say that I'm probably going to come back with Amy and do another session on it. But Brian Kohberger has accepted a plea. He is pleading guilty to 4 counts of murder in the Idaho murders, and fortunately or fortunately, he will be serving life in prison with no possibility of parole. But he pled guilty, essentially avoiding the death penalty. And I posted this on our Patreon today, and people had a lot of questions about that. So specific with not specifics to Coberger or maybe someone wanted to know, and I answered this, does the prosecution have to offer a deal? And of course the answer is no. But in this, yes, of course the answer is no. In this case, someone else asked me though, and maybe you could answer this, with so much seeming evidence, why would they?
There are 2 important reasons.
Okay.
One is resources. To try a death penalty case
Yeah.
would take full-time, multiple ADAs, multiple investigators, and every hour that they spend prosecuting Coberger is an hour they can't spend on prosecuting some other case. And it's not as if all of a sudden the budget is going to expand for that year and there will be, an additional 5 people who come in to take up the slack for
Right.
the 5 people who are spending full time on the death penalty case.
Right. Okay.
The second reason is what we just experienced today in the Sean Combs case.
Yeah.
Sometimes juries come back in a way that the prosecution does not want.
And
it is the risk of an individual who you believe is guilty of these heinous murders, potentially going free, even if it's 0.1%, is an enormous thing to deal with, particularly if the alternative is death by incarceration. Because saying you're taking the death penalty off of the table is not really true. You're just saying you're not getting out of jail until you die, whenever that happens.
That's interesting that you put it that way. The reason I think there were 4 families involved here, and there was a mixed reaction to being informed that the prosecution had reached a plea deal. And I think the outrage seemed to be from 2 of the families that they weren't consulted, they were informed after the fact. How often, in your experience, do prosecutors take into consideration the wishes of the family?
So under federal law, and I believe under Idaho law, the prosecutors were required to give notice to the families before the plea agreement was finalized.
Okay.
And there's
You're saying they knew before it was finalized that it could be happening.
I don't know if the prosecutors followed that law, but
I see.
but if they did, then the families of the victims would have known before the plea was finalized. But sometimes before it's finalized means a day before, and they're doing it to check the box. We gave notice ahead of time, not really to take the victim's family or the victim themselves into the decision-making process.
Right. So one of the things that I read was that yes, one of the families said we were notified long ago, a year ago or so, that a plea was a possibility, which makes perfect sense to me, but not notified that it was happening, and this family still believed they were going to trial. Um, People have asked my own opinion about this, about whether or not prosecutors, how much they should act on behest of the families. And ultimately, the prosecutor is a minister of justice, and they have to do what is justice and what the office seeks as justice and what the people say is justice. But in this case, I don't know, it somehow felt a little bit different, I might say. Ultimately, Brian Kohberger will spend the rest of his life in prison. Here's my question, and I think this is what maybe upset some of the families and other people as well. As part of his allocution, Brian Kohberger will likely be required, as I understand it, to state that he is what he did, maybe, or that he is guilty or that he accepts responsibility. But is there ever a time in which he would be required, or prosecutors would require someone like him to say why he did what he did? Because I think that is the real question that's bothering so many people, including the families. They just want to know why. Would he
Yeah,
ever be required to say that?
I in all the allocutions that I've ever seen, I have never seen a defendant required to answer why.
Yeah, I didn't think that was ever a requirement either, but I somehow was still hoping for the families that it might be. Well, okay. So Brian Kohberger, as I said, has entered a plea. I will talk a little bit more for my listeners and for people who are following. Amy and I are going to break down what we think is the why behind some of these crimes, especially with Brian Kohberger, but also with Diddy. Why he committed some of the crimes, what motivates people in his position to do some of the things that they do. This is kind of our specialty. Mitch, thank you so much for joining us tonight. Did we miss anything? Did I miss
I
anything?
think we've covered the entire waterfront.
I think so as well. Thank you so much for joining. And I think we got to all your questions. We missed Karen Reed. That'll have to be another time. Sorry, but I promise to get to that with you guys. But thank you all for joining us. And Mitch Epner, again, thank you for being here with us.
Thank you for having me.
All right. Good night, everyone. All right. So normally I would sign off here, Mitch, just so you know.
Sure. So thank you for
Hold
having
on
me.
1 second. Sorry. We are not signed off yet. So just give me 1 second, okay? Hey, Mitch, just give me 1 more second, okay?
Of course.
Sorry about that.